Welcome everybody to Fox Williams, but also to London International Disputes Week and this panel session on securities litigation and ESG. I fear we have a lot to cover because it's a fascinating topic. So I think we'll dive straight into it. But first of all, we should introduce ourselves, and I should say happy Pride to everybody. I'm Andrew Hill. I'm the head of the dispute resolution team here at Fox Williams, and I'm also the head of our securities litigation team. So this is very much my day job. I'm going to pass over to Phil, Marzena, and Laurel just to very briefly introduce themselves, and then we'll get into the topic.
So I'm Phil Hinks. I'm a barrister at 3 Verulam Buildings. I do a lot of group litigation, including securities litigation. I was involved in the Tesco securities action. I'm currently involved in the Glencore Section 90 and 90A claim.
Hi everyone, Marzena Meeson. I'm a director at the expert service team at Kroll. I'm an economist and I specialize in disputes, mainly in the EMEA region. Thank you.
Hi all. I'm Laurel Van Allen. I'm the president of Coherent Economics. I lead our finance practice where we do, among other things, a lot of securities litigation. I've also been on the Harvard Law School Forum for Corporate Governance, so this intersection of securities litigation and ESG is very near and dear to my heart. And London is lovely. I'm very pleased to be here in person, so thank you.
Well, yeah, thank you everybody, and particularly for Laurel for coming over to join us here. So let's dive in, and I think I didn't mean for the lawyers to sit on one side and the economists to sit on the other. We're hoping this will be a conversation and a real discussion for you. But to set the scene, I've asked Phil just to run everybody through at a high level what we're talking about when we're talking about securities litigation in the UK context.
Yeah, so here in England, we've got two main causes of action for entities and individuals who have bought shares on the basis of false or misleading statements or omissions by the issuers of those shares. So the first is a claim under Section 90 of the Financial Services and Markets Act 2000. Now, that is concerned with misstatements in or omissions from the prospectus, the issuer's prospectus, usually when the issuer first floats. It imposes a form of strict liability. There are 4 requirements to a viable claim. The first is that the defendant is a person responsible for the prospectus. Now, that will usually be the issuer, but it will also include directors and anybody else who have specified in the prospectus that they are responsible for its contents. The second is that the prospectus contains untrue or misleading statements, or there are wrongful omissions from the prospectus. And that will include things like a failure to state the information that's necessary for an investor to understand the true financial position of the issuer. The third requirement is that the claimant bought shares to which the prospectus applies. And the fourth requirement is that the claimant has suffered a loss in respect to those shares as a result of the untrue or misleading statements in the prospectus or the omissions from the prospectus. Now, the main defence to a claim under Section 90 is that the issuer or the director held a genuine belief that the statement, which is alleged to be a misstatement, was in fact true, or that the omission had been properly omitted from the prospectus, and that they held that belief reasonably, having made all inquiries as were reasonable in the circumstances. It's a long-standing claim. We've had a statutory form of liability for misstatements in prospectuses since 1890. The second cause of action is a claim under Section 90A of FISMA. Now, that is concerned with liability for misstatements in and omissions from an issuer's published information. So the ongoing publications that the issuer makes throughout the year in the form of its annual reports, its interim statements, and any ad hoc disclosures that it makes to the market. Now, that's a deceit-based form of statutory liability. There are 5 requirements to get one of these kind of claims off the ground. First of all, the defendant is the issuer of the securities. The claim is only available against the issuer. It's not available against the issuer's directors. Secondly, that the issuer's published information, so its annual reports and the like, contains untrue or misleading statements or actionable omissions, or that the issuer dishonestly delayed in publishing information to the market. The third requirement is that one of the issuer's persons discharging managerial responsibility, or PDMR, knew that the statement was untrue or misleading, or knew that the omission from the published information was a dishonest concealment of a material fact. Now, an issuer's PDMRs will typically be its registered directors, but in an appropriate situation, it might also include de facto directors and shadow directors. The fourth requirement is that the claimant acquired or continued to hold or disposed of securities in reliance upon the untrue or the misleading information. And the fifth requirement is that the claimant has suffered a loss as a result of the untrue or misleading information or the omissions. Now, in comparison with prospectus liability, Section 90A is a relatively new beast. We haven't had a form of action like this before 2006 in this jurisdiction.
Okay, thank you, Phil. And just to kind of tie it into our, the topic for our panel today, the next thing I wanted to just address was to, think about the subject matter of the cases that have come before the courts in England since these statutory provisions have been in place, and in particular, I would think in the last 10 or 11 years, because I think it's only really in this most recent period that we've seen the kind of burgeoning of securities litigation in London. And I think it's probably fair to say that we started with some pretty dry accounting misstatement or overstatement cases, like the Tesco one that Phil and I both worked on in different guises. But as time has passed, for various reasons, I think, but my thesis is with an ESG flavour to them all, we have seen the subject matter of these cases develop, and now we are, I think, seeing ESG come to the fore. So if we look at some of them, for instance, that are in the public domain, there is, as Phil mentioned, a large group of groups suing Glencore, following Glencore's admissions to bribery and corruption in various parts of the world that resulted in deferred prosecution agreements with the Department of Justice in the US and pleading guilty to charges brought against it by the Serious Fraud Office in the UK, amongst many other things. So there's a bribery and corruption aspect at the heart of that case. We're also acting for a group of investors against Petrofac, the oil and gas services business. That arises out of charges brought under the Bribery Act. So there's a bribery element to that. In fact, the timing of this session is really on point, because the first, I think I'm right in saying, the first English securities litigation case to make it to trial has made it to trial this week, and that is the investors group suing Serco, and the wrongdoing at the heart of that case, or the wrongdoing which wasn't disclosed to the market, which is the theory of that case, relates to the, I think, electronic tagging of prisoners and the defrauding, effectively, of the Ministry of Justice, who Serco was charging for providing those services. So it's, we've moved away from dry accounting cases, and I think we're into much more interesting territory. But, to one extent, we can be agnostic about the wrongdoing, because these cases are all about just the disparity between what the company is saying in public, what it's reporting to its shareholders, and what it's doing in private or behind closed doors. But I think, having said that, there certainly does seem to me to be an ESG dimension to these cases, and I think that's going to increase. But that's a lot of what we're going to be talking about this afternoon. Now, you've heard from the lawyers. I wanted to now pass over to Marzena and Laurel, just for them to explain or to tell us their perspective, what they're seeing, the kinds of cases they're being asked to work on as experts in this field. So, passing to Marzena first.
So, a lot of the cases that we've seen and worked on are still ongoing, and our work on those cases remain confidential. So I'll be speaking a bit more generally about the cases that we've seen and considered. So I think we have seen both FISMA 90 and FISMA 90A cases, and some are pursued as group litigation on behalf of multiple shareholders. Others are pursued by individual investors. And I would say that there is no general trend in terms of industries of the defendant firms. We've experienced, from our experience, those firms come from kind of a wide range of industries, which, it's not something I think that we expected to see such a wide range of ESG failings or general failings. And from an economist perspective, I think the big thing about those cases is the amount of data to consider, the amount of transactions, especially if it's group litigation. The buying and selling by institutional investors, it's just a lot of data to analyze and to look at.
So they're expensive cases to run.
They can be.
It's complicated for sure.
And Laurel, from the US and Canadian perspective.
Sure. So some of you may have heard the US is a pretty litigious place. And so as a result of which there's a long history, decades history of a lot of securities litigation, which historically has been, event-driven securities litigation. So there's some corrective disclosures, some event that occurs, which causes private class actions to arise. In the ESG space, we're seeing a lot of that, but we're also seeing a lot of state and federal actions, efforts to sort of get companies held accountable for potential material misstatements or omissions related to material risks, especially on the environmental side. So at least in the U.S. and in Canada, we're seeing a lot of sort of mineral, mining, resource-oriented companies as well as energy companies facing a variety of litigation, all specific to material risks. And oftentimes those cases arise when, say, there's a mine incident or an accident. Those are sort of the obvious cases where you would expect to see a lot of litigation. And as an economist, there are really two areas where we can lend, I think, the best support and help for these cases. One is assessing materiality. Are these risks material, and were there material misstatements or omissions in the made by the issuer? And if there were, what are the corresponding losses? And so Marzena and I were talking about how in the U.S., economists sort of have our tools in the toolbox we've been using for decades that are kind of well tested and expected to be presented within a court environment. And it sounds like the landscape here is maybe still developing, and maybe there's a little trepidation about some of the methods that we use widely over North America.
And Laurel, you mentioned to me some additional factors that you've seen that have influencing the focus of private securities cases.
Oh, that's right. So there's environmental issues are, I think, a very hot topic with securities litigation, but also the social component, increasingly has led to some significant securities cases. And sort of one famously is L Brands, which was the parent company of Victoria's Secret. And L Brands was encountering really two overlapping factors at once. Consumer preferences were changing. They were shifting towards body positivity. And so the company was facing challenges in terms of a business model and a viable business model that it was affecting its stock price. At the same time, its founder and some of its key executives were accused of wrongdoing within the organization and sexual harassment, creating a toxic culture that was not consistent with what they stated were in their public filings. The founder of L Brands, Les Wexner, was an associate of Jeffrey Epstein. And so as news about Mr. Epstein came to light, that was actually affecting the stock price performance of L Brands. So we're seeing social issues becoming increasingly important in North America, as well as environmental. And then more broadly, governance continues to be an important topic, that directors are maintaining internal controls, making proper disclosures, and monitoring the internal performance of the firms.
And from my perspective, I find that really interesting and positive. And I'm pleased to say that only the last couple of weeks, on the 17th of May, we launched an S case on behalf of a group of investors against Boohoo, the online fashion retailer, for alleged forced labour and modern slavery in its supply chain. And from a personal perspective, I think that's our first S case, the first one that I've worked on, and I think it's one of the first potentially that have been brought in England using that or considering that ESG framework. So I think, and particularly, I was pleased to see certain investors really engaging with that topic and that wrongdoing and wanting to join that group action here, and in particular. I'm going to name check our primary client, the California State Teachers Retirement System, was really keen to join this case and to have its name on the top of the claimant list. And I think that really speaks to what I would say a positive example of an investor who is keen to hold the companies to account in which they're investing. As the topic of this panel is heading us towards.
Yeah, if I could just add to that, we're seeing a lot of activist investors really voting with their feet, making demands about, slates of directors, that directors must be taking ESG policies seriously, and that's having consequences for the performance of firms and how investors are assessing long-term performance of companies. And I think Marzena is going to be talking about the Kroll study, but that's certainly suggesting investors are voting with their feet in terms of moving towards more sustainable funds. So all of those actions, as well as the regulatory changes, are shifting the landscape for securities litigation.
And now, just focusing on some of the mechanics now of these cases, I think we can come back to the ESG aspect. But first of all, Marzena, can you talk us through, from an economist's point of view, the considerations that you take into account when you're trying to assess the potential loss of the investors?
When considering a case, the specifics of the case will always, be very important and will have to be taken into account. But for an ESG case, the potential loss of investors might be a mixture of ESG and financial factors, and I would say that most of the cases that we've seen have got an ESG angle to it. Typically, historically, maybe more on the G side, on the governance. Now it's moving more to the cases where the ESG issue is at the heart of the case. But I would say most of the cases that we've seen have got a mixture of the ESG and the financial factors that investors would consider, and the share or the value of the company might be affected through both channels. So taking bribery as an example, on the financial side, investors might be worried about big penalties or costly investigations. Also, if the profits in the past have been supported or aided by the bribery, going forward, perhaps they will not be achievable. But on the ESG side, unethical behaviour might drive the demand away from the particular company, and that's the kind of additional factor that would have to be considered. And just to add to that, I think the complexity of the ESG impact is that it might take time because there might be some knock-on effects. When the unethical behaviour, for example, becomes public, it may take time to have the knock-on effect on the supply chain, on the issues within the supply chain and client relationship. And that might all come into play when assessing investors' losses.
And I think that point is really interesting because often these cases are, anecdotally referred to as stock drop cases. So you're looking for one single stock drop. The reaction of the market to a scandal that's come out into the public domain after having been, hidden by the company for a period of time. And I think Marzena, your point is in an ESG context that will be part of the analysis, but there may be a lot more to it than that because these things take time to be uncovered effectively, and the market needs time, I suppose, to understand really what is going on at that company.
Especially if the news becomes public through an expose in a newspaper, or when it's not as straightforward as with other cases where the correction comes from the firm and it's everything's available
straight away
and investors can kind of consider all the facts.
Yeah, and I think that's, looking at the cases that we've seen in England, you can see, you can see the range of ways in which these disclosures come about. Even Tesco, that was an internal whistleblower going to the new CEO. The CEO made an announcement. So there was a corrective disclosure voluntarily by the company, but even then it took them time to figure out what the true scale of the wrongdoing was. And there turned out to be 3 corrective disclosures. So I think it's probably actually the rare case where there's just one, even in a relatively simple context like an accounting misstatement case.
Sure. If you think about what's happened with Glencore, so there were rumours in the market for years that Glencore was engaged in bribery and corruption, and there were various exposés by private journalists which got some traction. You saw sort of fairly small effects on the stock price, and then investigations began and announcements of investigations, and then you saw the stock price starting to tipple. And it was only really after the announcements of prosecutions being commenced and deferred prosecution agreements being entered into, that the share price really, really dropped. So these things, they very rarely happen sort of immediately. It takes place over a period of time.
And Laurel, your perspective from the US?
Likewise, I think we oftentimes see partial disclosures over time, and then as economists, we have to really assess, what information is being absorbed in the market and how are investors responding. And ultimately, the question is, are ESG related disclosures, like with any disclosure, are they material, and do investors care about them? Or if there are misrepresentations or omissions, is that material information to investors? And looking at the disclosures over time and the corresponding stock prices is sort of the gold standard for how economists look at these issues, at least in North America.
And so I suppose posing the question the other way around, if there's no stock drop, if the market doesn't seem to have reacted to the scandal coming out, do we think that means there's therefore no loss for the investor? Marzena, do you have a view on that?
I think firstly you would have to consider the issue of no stock drop. Is it no drop attributable to the news becoming public, or is it no stock drop overall? Because it might be two different things, and it might be possible that that the public announcement does impact negatively on the share price, but other market movements, whether at kind of market-wide level, industry-wide level, or even company-specific news, moves the price the other way, and overall you might see no significant change. But the two forces kind of going in two different directions and offsetting each other, and underneath that kind of top level. But if there is no, I think other methodologies might be considered in some situations. If a particular part of a company portfolio, becomes worthless following an announcement, perhaps there is an alternative way of valuing that change. So I think that it might be helpful to consider other approaches to corroborate the findings. But then alternatively, there is potentially a scenario where the news become public over time, or investors over time become convinced that certain promises will not be maintained, or certain things that were promised will not happen, and that realization may happen at different times for different investors. And I can imagine that this would smooth that the news becoming public for each investor individually, depending on their perceptions. And in such case, perhaps it would be a much, there wouldn't be a one-off kind of trigger point event, but instead it would be a bit more gradual.
Thanks, Marzena. And Laurel, the L Brands case example seemed really fascinating on this point as well.
I agree. I think the content of it is really rich, but also along the lines of what Marzena was saying, in the case of L Brands, when the founder and Jeffrey Epstein's associate ultimately resigned, the company disclosed they were also pursuing strategic alternatives at the same time, but the stock price actually went up. And so that was a case where there'd been, over a year, several year history of adverse information accumulating over time, as well as the company just having been misguided, not responding to consumer preferences quickly. And so, this is my plug for econometric tools, which are used widely in North America to analyze this. And maybe there's still some reluctance over here, but I think this lenses, econometric tools are in our toolbox, and they really lend themselves to answering this question of, is the price reaction different from what would have been expected, and are there ways to measure this artificial inflation arising from wrongdoing, even if you don't see a stock drop, even if you see a stock price increase? You can assess whether that increase would have been higher in the absence of a material adverse disclosure. So I think it can be complicated, and the short answer is it depends, but I also think we have some really good tools to analyze these things.
Thank you. Now, jumping back over to the legal side, we've been talking about these questions from an economist's perspective. But we have to remember that in England we have to deal with the legal framework that we have in which to bring these claims. And so I'll ask Phil again if he can just set the framework for us and for you in relation to the measure of loss or the calculation of loss and how that might occur in English securities cases.
It's kind of difficult to say because we haven't had a judgment that's led to an award of damages, amazingly, in any of these securities cases yet. So, there's a healthy degree of guesswork in all of this. I think starting at the basic level, what you can say for sure is that the award of damages in all of these cases is going to be the tortious award of damages. So the purpose behind the damages award that the court will give will be to put the claimants, to put the investors into the position that they would have been in had the wrongdoing not occurred. But within that tortious measure, there's a fairly significant issue about whether the appropriate measure of loss is the measure of loss that applies in common law negligent misstatement cases, or the measure of loss that applies in deceit cases. So when you're dealing with negligent misstatement, the losses that are recoverable are typically confined to losses that were reasonably foreseeable at the time of, in this case, the misstatement or the omission from the prospectus, let's say. Whereas in claims for deceit, the cases often say that damages are at large and there's no such limitation which applies. And that difference is potentially very significant in securities litigation because the market's fluctuating all the time, and damages for losses caused by fluctuations in the market value that have got nothing to do with the misstatement that's the subject of the claim would be recoverable on the deceit basis, but wouldn't be recoverable on the negligence measure. So it's an important issue. I mean, looking at the two claims that we have in our claim box, the claim under Section 90A is probably the most straightforward because this is a deceit-based form of statutory liability. Chances are that the deceit measure is going to apply. I mean, one has to establish fraud. You've got to show knowledge on the part of one of the directors. So it would be unusual if, having been put to that requirement, the law would only afford you like a negligence measure of loss. The position under Section 90 is more debatable. So if you remember from what I was saying at the start, it's a form of strict liability where the main defence is one of the directors or the issuer showing that it took all reasonable steps to ensure that the disclosures that it made were truthful. And that sort of points in favour of a negligence measure. That's kind of what you would expect. But it's fair to say that there is case law under some of the precursors to the current Section 90, which date back into the 1800s, which support the view that the deceit measure might be available. So there's argument to be had on that. In addition to the measure of loss, one of the key and unresolved issues is the date on which the assessment of loss is to be carried out. And it seems that there are this is sort of what's being debated in the current cases anyway. There are three real options for the court. So the first is assessing loss as at the date of the transaction. So what you would do is to give credit for the true value of the shares as at the date that the investor acquired those shares. The second is the date of discovery of the wrongdoing, of the misstatement or the omission. So you'd give credit for the value of the shares as at that date rather than the earlier date of acquisition, on the basis that until you found out about the wrongdoing, you were locked into an artificially inflated market. And then the third is the date of judgment, and this is this sort of goes back to a point we were discussing earlier, that you often get a drip feeding of information to the market, and the market reacts accordingly. And sometimes it's not until the CEO's been in the box and the judgments come out that the true extent of the wrongdoing and the true extent of the misstatements is finally revealed to the market. And unless that's baked in to the share price, then you'll see further changes in the share price at that point. Now, the conventional view is that the damages should be assessed as at the date of transaction, but there's no authority on that point, and it's very possible that different approaches will be adopted in different cases with a view to ensuring as best we can that the measure of damages which is ultimately awarded, puts the claimants, the investors, into the position that they would have been in had this wrongdoing not taken place.
Thanks, Phil. So, having said we need to think about this within a legal framework, the reality is there is no legal framework yet, or we're still developing it. So, Marzena and Laurel, again, from the economist's point of view, how do you turn those words into numbers ultimately when you're looking to assess the potential loss or to estimate the potential loss in this kind of situation, or as things stand at the moment in England? Marzena?
The legal framework will have huge consequences on the methodology used for calculation of losses, and depending on the framework that is used, you might end up with two very significantly different values of losses, and then within the fraud measure of damages, the date will also be a very significant factor in terms of what the total loss is due to investors. So, if the fraud measure of losses is available, then as Phil said, investors will be able to recoup losses that are unrelated to the failings of the firm, and might be due to wider market movements. It was if the fraud measure is not available and investors can recoup and the loss is equal to if the claimants may only be put in a position where they still purchase the shares, but at a lower price, then the loss will be equal to the difference between the price they paid and the counterfactual price in the scenario where the misstatements or omissions did not take place. So two very different approaches and potentially very different loss estimates. And it's impossible to say which framework would lead to higher losses, because it will very much depend on the trend of the price of the share price. Yes, very, very relevant and very interesting for the purpose of the damages calculations as well.
Absolutely, and I think we've seen that this year, because we've been developing two cases this year, as I mentioned, one of them, and another one still in the pipeline, working with different experts, looking at different measures, and it really has brought home to me and to the team here at Fox Williams that it really is very fact specific and very case specific, because depending on the pattern of the stock price of the company over time, will drive you towards favouring a particular methodology, which I suppose we have the luxury on the claimant side of at least putting forward what we think is the best for the claimants. Laurel, from the US side, I mean, one thing that strikes me, and is a question that we get a lot from US investors looking to consider English cases, are there differences potentially between the UK and the American framework? And one in particular, I know you've commented on in our discussions before today. The question of a holder of shares during the relevant period, as opposed to an acquirer during the relevant period. How is that dealt with in the US, or is it not at all?
In the U.S. and in Canada, or at least in the securities cases I've worked on in Canada, you're really an investor is typically only a class member if they purchased during the period when the stock was artificially inflated due to the alleged misstatement or omission. And if they held through the corrective disclosure, or at least the partial corrective disclosure. I think as previously noted here, the legal framework really dictates how the damages are calculated. And the specific facts and circumstances for a company and its stock price can lead to wildly different results depending on whether you're using the method I just suggested in terms of who's an eligible class member versus I've seen derivative cases where the claim was all shares outstanding on a particular date when a corrective disclosure occurred are eligible for recovery. And that can lead to a wildly different answer.
Thank you, Laurel. I think now we've taken a deep dive into these cases and the economic analysis of them, and I wanted to kind of step back a little bit, zone out potentially, but not zoning out, but do some horizon scanning. And these are questions I think for any of us on the panel to think about and to address. I think we've touched on some of these points already as we've been going, but typically, as I mentioned before, at least at the beginning of the analysis on these cases, or to even identify these cases to begin with, we do look for stock drops. We're looking for the market to react to the disclosure, however it comes out, and whether it's fully corrective or not. You don't know it until you've seen it, so you've got to see something to kind of gauge your interest. So. Again, coming back to the topic too, if these cases do rely on stock drops, then there is an opportunity provided by securities litigation to investors to hold the public companies in which they invest to account, but perhaps that's nevertheless naturally limited by that point. If there's no stock drop, then perhaps no one notices. Therefore, perhaps no one realizes. There may be a claim or a case there. And I suppose that's a question, do we agree? And I think we've probably answered the question already that we don't, I think, and I'm glad to hear it, that, in the right circumstances, there may well be, a more nuanced and sophisticated analysis of the loss will get us past that initial presumption that, no stock drop, therefore no loss. And certainly, as someone focused on this area entirely, that's good, and I'm glad to hear it. A particular example that has sprung to mind, and I've been conscious of the last couple of years and been wanting to figure out a solution for, was essentially an event-driven situation in my home country in Australia. Rio Tinto, I think one of the world's largest mining companies, in 2020, which is obviously a busy year, unfortunately blew up an area of land which was sacred to the indigenous population of that location in Western Australia, apparently showing signs of human habitation for 46,000 years. And they blew it up because they wanted to expand the mine. There was public outrage, there was a parliamentary inquiry, the CEO and the senior management were forced out. So it was a huge deal in the Australian context, but the stock price didn't seem to move. And in fact, looking at the time period when this was happening, again, it was a busy time period. It was March 2020 through to July 2020. So again, other factors are impacting the share price. But ultimately, I think at a macroeconomic level, the mining industry in Australia in particular was booming. So effectively Rio Tinto showed no signs of any drop in value and kept powering along. And I've always looked at that case and thought, oh, you know what, that should be a case. I'd love to bring that kind of a case on behalf of investors. But how do I unlock that case? How do we figure out whether there's a loss there if the share price is on an upwards trajectory? And I think Laurel and Marzena, you've already touched on that. Various ways that could be tools in the toolbox that we could use to unlock that, to say, well, okay, sure, the stock price had continued to increase during that period of time, but for the scandal, what might have happened? And so I think that's been, it's a really valuable discussion, I think, for us to touch on, and I think we've done that today. But do you agree, Laurel, Marzena?
Yeah, absolutely, I agree. And from my perspective, the more there are regulatory disclosure requirements, the more we're going to see actions that are securities-related actions in this ESG space. And, there are all these different tools and prongs to hold firms accountable. And whether that's through activist investors, through regulations, and consequently through private action, it seems as though, and the Kroll study suggests, investors are caring about these things. And so we want to be able to disentangle what the effect is, even if it doesn't manifest itself in an immediate stock price drop.
Absolutely. And that's a great segue into the Kroll report, which I know Marzena's been dying to talk to us about. So, Marzena, can you please just educate the audience on the findings of that report?
So in last year, 2023, Kroll has prepared a study that looked at the link between the ESG ratings and investor returns. So let me just provide a bit of background to start with on the ESG ratings, because it's quite relevant. So sustainable investments are growing and accounted for 36% of all investments in the developed markets in 2020. But the question remains, what qualifies as an ESG focus or sustainable focus investment? And a lot of work has been done in this space over the last few years, but it's still very much work in progress. So just to provide an example, a change in methodology in 2022 reduced the number of firms that qualified as sustainable by over 50%. So there is still a lot of discussions on this topic. And then the information that is used for the assessment of ESG ratings, that's also something that needs more work on. And only 64% of information provided for the ESG assessment has obtained assurance or verification in 2021. So there is still a lot of uncertainty in this area. And I think it's fair to say that overall ESG ratings might be a bit confusing, because they consist of the three pillars: environmental, social, and governance. And a company that scores well on the environmental front can have a poor score on the in social governance factors. And I think the Kroll report provides the example of Tesla, who got the top scores at certain points in time, but then at others it was downgraded by a couple of ratings. So being good in one area doesn't guarantee that your overall score will be high. So then the Kroll study looked at the link between the differences in performance of portfolios with different ratings, and the rating that was selected for the study is the MSCI, according to MSCI, their ESG ratings aim to measure the company's management and financially relevance ESG risks and opportunities. So that definition in itself, it provides just one way of looking at ESG factors. And MSCI calculates the overall rating by aggregating the rating in each of the three pillars of ESG. So in terms of results, the across the global investments, the Kroll study found that ESG leaders who have been defined as the top 2 ratings on a 7-point scale have performed significantly better than ESG laggards, who were the bottom 2 ratings on the ESG scale, with around 50% premium in returns during the period between 2013 and 2020 or 2021. So the performance overall was significantly higher. I think the average return for the leaders was 12.9%. Versus 8.6 for the laggards. So overall, ESG-focused companies have performed better across the world. But it's worth noting that this result did not hold true for all industries and for all countries. Each case would have to be considered separately because it's not something that was found to hold universally. And the report already mentions that there are other things to explore in the future, such as are bigger companies getting even better returns, or bigger ESG-focused companies getting better returns than the smaller ones. It is something that still needs to be explored.
Thanks, Marzena. Speaking personally, I'm really excited about this report, and one of the reasons why I wanted Marzena to be on the panel to talk to us about this, because this is, again, a question that I've been wondering about or pondering over the last few years, given the rise or the potential rise in greenwashing claims. I think a few years ago we started looking at greenwashing claims in the context of damages actions where you need to show loss, as we've been talking about this afternoon, and it always seemed to me that we hadn't quite passed the tipping point yet, so we couldn't really say that other than the distress or the disappointment or the anger potentially of being tricked as an investor into investing in a green-focused or ESG-focused fund, we might not have actually suffered any loss, so we haven't got a claim. But I think what this Kroll report says, obviously, specific to some industries and in some countries, but I think perhaps we have passed the tipping point now, and in the appropriate circumstances, we'll, using the toolbox and everything in it, we'll be able to show that or make good greenwashing claims on behalf of investors, because it is becoming the case, and I'm hoping these trends continue, that, as the Kroll report says, if you're an ESG leader, you'll be outperforming an ESG laggard. And obviously the corollary of that is, if you're an ESG laggard, but you're pretending to be a leader, you're misleading the market, then investors are investing in you on that basis. And so we will be able to show the disparity and the loss there. Now, I'm conscious of time, and clearly you can tell we could talk about these issues all afternoon. I think I get in trouble from LIDW if we go much further over the deadline or the time limit for this talk. We did want to offer the opportunity for any questions from the audience, and I should say that we had more on the agenda. We wanted to talk about Client Earth and Shell. We wanted to talk about what's happening with activist investors in Exxon at the moment, the AGM at Shell only a couple of weeks ago. But there's a lot going on in this space, I suppose, is the point. And I guess I might ask the panel, without having pre-warned them, just to offer some closing reflections. I suppose, from my point of view, I would say, I'm a strong believer that securities litigation, should form part of the ESG framework that investors consider, whether they call it ESG or whether they call it stewardship or governance. It's fundamentally about trying to keep or hold the companies in which they invest to account. And I think we've tried to demonstrate that it's one of the tools that is available to investors. And they might even get some compensation at the end of the day. So it could be a win-win. Phil, any sort of closing remarks from your perspective?
Well,
have I convinced you that ESG and securities litigation go together?
I did not need convincing.
Okay.
This. All that I would say is there are a number of securities claims that are going through the courts at the moment that have something of an ESG angle. I know from cases that I'm also involved in that haven't yet issued, and the word on the streets that there are a number of others, all ESG angle Section 90 and Section 90A claims that we're going to hear about in recent times. So I see this as very much a growth area for the English market.
Thanks, Phil. And Marzena, Laurel, from the economist's perspective?
I think I'd say from a policy standpoint, regulation is going to affect disclosures, which are going to affect investors and stock prices and how markets are reacting. So I think thinking about regulations is important, especially anticipating maybe where litigation is going to expand in the future. In the U.S., the Securities and Exchange Commission, the SEC, recently issued a set of rules on climate-related disclosures where companies are, if the rules actually go through, will be required to disclose material risks with greater specificity than they've been held in the past. And that's led to a variety of disclosures, either from the leaders or the laggards, as to what their true risks are. So I think that could be a natural experiment that may shake things up a little bit. We may be seeing more specific and precise disclosures, especially from oil and gas, energy, mineral, mining, other industries where you can see a real tie to these ESG disclosures and their actual expected long-term performance. And so I would encourage those of you here in the UK to keep an eye on that. And also, as these policies become more widespread and globally, I think it's going to affect investor performance and stock price performance.
From me, I find it super interesting that what you said, that the trial has started on a Bismarck case this week, because that might provide a bit more certainty over the approach that the experts have to take.
Absolutely. I can see a couple of hands up. In fact, I can see three. We have a mic. Shall we go to Ollie Hayes, please, first?
Hi there. To the extent that the panel are aware of a recent Australian securities action decision involving Commonwealth Bank, does anyone have any views on how that might inform your view on how an English court might decide a similar case? I can provide some very high-level details.
I'm not aware of it, so you'd better.
This is an amateur summary of the case. It was a case alleging an artificial inflation in the stock drop of Commonwealth Bank in relation to AML failings which were not disclosed to the bank. When the government body investigating those failings announced its investigation, the stock dropped 5%. And then in a slightly surprising decision, in a jurisdiction where there have also been relatively few decisions on securities cases, I think there's only been 3, and a lot of these cases settle, the court ruled in favour of the bank and said that a reasonable investor wouldn't have expected this information to have affected the share price. I may not have articulated that perfectly, but it was a very surprising decision, and the funder and the law firm in question are apparently considering an appeal.
Oh, I mean, I hope they do. You've caught me out as an Aussie. I'm not fully au fait with that case. I mean, it sounds a bit like the issues that HSBC and a number of other banks have had over the last few years, where they've not disclosed the AML risks that they're exposing themselves to when they don't have proper governance or AML policies or processes in place. I mean, that does sound surprising, and I hope it's appealed. But it's a good point, though, you make tangentially. You know, the Australian class action regime has been in place since 1992, and I think there have only been 3 cases that have made it to the judgment point. I think a few more might have made it to trial, but have settled. And the first of those cases to make it to judgment didn't happen until 2019. So it took 27 years to get a judgment out of a class action regime, which has many benefits, like Australia. So if the Serco trial makes it to the end, and if we get a judgment off the back of that within sort of 10 years of these cases starting in England, we'll be doing very well. But let's see.
It sounds like an issue that comes up from time to time in our case is a materiality. So what a number of the issuers often try to say is that alleged untrue statements, misleading statements or omissions from prospectuses or published information are only actionable to the extent they are material. And there's no kind of ruling that's ever happened on this, and there's no kind of set definition of materiality. It sort of depends on the context and the type of untrue statements that you're dealing with. So, for instance, in the, as Andrew would put it, the dry accounting cases like Tesco, where you're dealing with profit overstatements, and you're dealing with a number, a differential in the financial statements. What was said by the issuer in that case was that the claim could only get off the ground if the differential was greater than accountancy materiality threshold. And in Glencore, the issuer is also alleging that untrue statements are only actionable to the extent that they're material. But those are more kind of narrative statements that are in play about Glencore's compliance with material laws and good governance. So it's much harder to pin down this sort of alleged materiality requirement when one's dealing with something other than figures.
And I mean, even in that Tesco example, the defendant was arguing materiality was relevant, and we said, well, is it quantitative materiality? Is it qualitative materiality? I mean, if it's fraud, it's fraud. It shouldn't matter if it's only a copper mine in the DRC. These things should be taken seriously. And so I think the market normally determines and demonstrates whether it's material when it reacts. Now, I know Louise and Andrew also had some questions, if we've got time, and the patients. Should we go to Louise first?
Well, thank you, and I'm delighted to hear that there's going to be plenty of precedent on the fact that you can get deceit damages. That's great. If you could get a few more precedents on the books, Philip, that would be great.
I'll see what I can do.
In the meantime, I've got loads of questions, but I'm going to try and keep it to one. Has anyone on the panel had much experience of the argument that the company didn't have knowledge because it was just the director, or and it was a rogue director? How have you been able to show that there was knowledge of the fraud?
I mean, that issue only really, I think, arises in Section 90A cases. And in those kind of cases, although it's sometimes put in issue, generally it's sufficient to show that a director knew about it. So if you can establish there was a rotten egg, and it's usually indicative if that rotten egg has since been fired and there's been a clean sweep of the board. If you can establish that one person had knowledge, the PDMR knowledge, then it doesn't matter. You don't need to get into those kind of complicated issues of whether or not the rogue director's knowledge should properly be attributed to the company because he was off on a frolic of his own. That's not an issue that plagues our securities litigation.
Okay, and then one last quick question before I pass over to Nick. But the causation is always an issue. I'm a funder, and we're always looking at the causation. And let's look at the stock price history. Yes, the price went down, but then over a certain period it went up. And in fact, they made decision X, but had they made decision Y, it would have dropped even more. So actually, it was quite good that stock only dropped by X percent. Have you got much experience of looking at those sort of situations?
Speaking from the economist standpoint, I mean, we always want to disentangle all the confounding information, and so you can have complicated situations. But generally, if there's harm, if you can really isolate what the specific harm is, notwithstanding any other but-for world scenarios, then we really try and isolate that and say, and indeed, there's harm, and it doesn't matter if they had done, 10 other things. But I don't know if that's a satisfactory answer for everyone here.
And thanks. There's maybe a slight sort of nice, easy tap across the goal for you if you want to speak about some of the other cases you want to talk about. But and yeah, it might be a slightly different answer for the 1998 cases to a class action. But how accommodating or otherwise is the court when it comes to showing that you held or invested on the back of a belief, as opposed to the fact you just happened to have the shares at the right time gets you into a class? Do you have to prove that you invested or held, consciously, because on the back of an issuer's statement or activity?
Well, now you're asking me to reveal the secret sauce. Well, the answer is yes. I mean, the defendants obviously put us to the test on that front because, again, one of the big differences between the US and the English system and compared to the Australian or the Canadian system, it's opt-in here. It's not opt-out. So each investor has to sign up to these cases, and so obviously then the defendants say, well, each and every one of the investors needs to prove their case. Whether you have 200 or 500 investors in your group, each of them are going to have to demonstrate that. And there is, in the paragraph 3 cause of action under Section 90A, there is a reliance requirement on the face of the statute, so we have to grapple with that. I think, again, the defendants try to put the hurdle as high as possible and say it has to be eyeball reliance, and if it's a overstatement of commercial income like it was in Tesco, and it's on page 275, footnote 3 of the annual report, we need to show every time we made a trade that we relied on that, and they're suggesting we need to have a minute of the investment committee or an email from someone saying buy based on that, which is, I think, completely unrealistic. So we are trying and running all available arguments effectively to counter that, whether it's indirect reliance or market price reliance or price reliance. So far, I've tried to not use, but effectively we're trying to follow the fraud on the market presumption that has been adopted in the US. But I get the sense, and I think I can say this as an Australian with a little bit of detachment, that there is a reluctance within some parts of the English judicial system to, or a nervousness about American-style class actions, and so I tend to use other phrases like market-based causation or price causation when I really mean fraud on the market. But because that's so identifiable with the US approach, I don't mention that. But that's effectively what we are trying to do. And then the other point is, there are, Section 90 in prospectus cases stand separate. There is no reliance requirement, so the fact they issued a prospectus and you bought shares should be enough, although Glencore is trying to make an issue on that. But then again, under Section 90A cases, there is another cause of action under paragraph 5 for delay. If you've dishonestly delayed releasing information, then there's nothing to have relied on in making your investment decision. So you don't have to satisfy that reliance requirement. So we look for every avenue that we can to get past those hurdles until we get some precedent from the court to guide us.
Do you look at secondary markets, like people who sold on and sold on and sold on? Have you got any precedents?
No. But we still do. And again, there's a debate. Again, in the Glencore cases that are going through, and I'm sure in Serco that's in trial this week. I don't know that case in granular detail, but there's a debate about what the aftermarket is, what the secondary market is, where do those markets finish and start. But on the claimant side, we just try for the best and see what we can achieve. I think we're massively over time now, and I'm probably going to be fined by the LIDW. We should have booked 2 slots and not 1. But anyway, thank you very much, everybody, for coming and for listening intently and for asking questions. We had some people online, and I don't know if no questions have come through. So we can close that now. And so it just remains for me to say thank you, everybody, and enjoy the rest of LIDW. I think we have refreshments if anyone wants to stay across the hall. But otherwise, if you have other sessions to get to, I hope you enjoy them. Thank you for coming. And thanks to the
Thank you all.